As you know, the state presented its closing yesterday, and at this time, we'll call upon the defense for its close.
Thank you, Your Honor. The government didn't build a case. It bought one. An expensive expert, desperate snitches. But you can't buy your way past the truth. And the truth is, to quote Hakeem Robinson's sister, Blue's daughter, hell no. This is not the guy in the video. Let me walk you through some maps to explain what happened that day. Mike, if you would. So on January 15th, 2020, Charles McCormick was at 7001 Merrill Road. Over at the Publix, you had Officer Jimmy Collins. At around 11 o'clock, Charles McCormick is shot and killed. The killers jump inside of the vehicle and they flee. Now, Officer Collins was fast enough, and you can see it in the dash cam video, that his car is parked down near that yellow line. He sprints. He doesn't run. His words. He sprints, gets into his cruiser, and gets behind that vehicle. And then there's a pursuit. They go out into Merrill Road, turn south, go all the way down to Townsend. Now, the first mark is where the car accident happens. A car crashes, 3 people jump out. 2 of them run south to Barbara Buckley's house. The focus for us here in our argument is the one that Officer Collins says runs westbound. Now, you heard some testimony. Officer Graham took the stand and talked to you about how he was in the area of Carlotta, saw somebody running westbound. Then, you also heard from Renata Boston, who lived at 7201 Arlington Expressway, that was also person that ran westbound. Now, an opening statement, which feels like months ago, Ms. Kawas got up here and said, watch what the government's going to do. They're going to tailor their evidence. They're not going to give it all to you. When you trust the facts of your case and you believe that the facts of your case are going to prove it beyond a reasonable doubt, you don't tailor it. You give it to the jury. As the government, you give it to the jury and let the jury decide. But that's not what we saw. Victor Kruger, he was back. He was in his vehicle. Dash cam, eerily music comes on when the shooting starts. He took the stand. The government didn't ask him for the description of the shooter. They left that out. I had to pull it out of him. I shouldn't have to do that as a defense, to pull it out of him, that what he saw was somebody that was very slight. Don't let this government get up here in their rebuttal and not answer the question to you why they didn't give that to you. Why are they tailoring it and giving you only the things that fit their case, but not those that are against it? Now, that applied to the witnesses as well, too. Jarvis Roberts, admittedly, he's far away, but he's a witness. Why did we have to call him? Jarvis, working at Hibbett Sports, is at his vehicle. It's only a couple of seconds. And he sees somebody and he describes it. It doesn't fit their case. They choose not to call that witness. I agree, they don't have to call everybody. But there's a handful of eyewitnesses. His testimony took minutes. Why did we have to call it? Don't let them get up here and not answer that question. Instead, they want to focus and get into a back and forth with Mr. Roberts that he was maybe 5 yards further away than he said. Was it 25? Was it 30 yards? Meanwhile, they're overlooking the inches and pounds discrepancy in between the descriptions in their case. Now, the reason why we're bringing the defense, we shouldn't have to, bringing all of these witnesses to you, is for one simple thing. A dozen people, including police officers, are not going to consistently get it wrong. 12 people would have to be wrong, but consistent. Not tall and stocky, short and skinny. That doesn't make sense. Also, us as human beings, we understand that if somebody's running, that's going to drop their height. If they're far away, it's going to drop their height. I don't think that the people that are in the back of the courtroom are 12 inches tall. I have depth perception. I have the ability to be able to say, it's at a distance. But there are some people, when you get up over 6 feet, when you get up over 200 pounds, not a lot of human beings are that size. And you can very quickly determine that is not a normal sized human being. That is not a normal sized human being. Stand up, Hakeem. I'm a big guy. He makes me look small. Take a seat. So, talking about the witnesses that consistently, according to the government, get it wrong and describe somebody who's short and skinny. Michael Williams, military vet, undoubtedly has training in stressful situations. He gives a description that doesn't fit their case, so they don't call him. Maybe hoping that we won't call him. Why wouldn't they call him? His testimony was minutes. But he says stuff that goes against their case, consistent with everybody else. Next, we have Renata Boston. I'm sorry, I forgot somebody, and this one's important. Tashita Saunders. She was the one that was inside of the staffing place where Charles McCormick was right before. Now, anything that I'm saying here, I beg you, ask for the transcript. Fact check everything that I'm saying.
Yeah, sustained.
You've taken copious notes. I trust you remember the testimony, and you'll be able to fact check me in your own mind against the government. Tashita Saunders got up here, and the government questioned her. How tall is the shooter? Mr. Cooper then argued in his closing argument, taller than Charles McCormick. That is not what she said. We had to bring it out of her. Ms. Khawass on cross-examination, 5'8", 5'9", skinny. It's as if the government is trying to blur the lines to increase the height of the shooter and decrease the height of my client because it's the only way they can bridge that gap. We shouldn't have to give you what is the truth of what the witnesses said. Tashita Saunders said 5'8", 5'9". Not because if you say taller than Charles McCormick, well, that could go all the way up. She put a cap on it. We shouldn't have to bring it out. Now, Renata Boston. Renata Boston was not upstairs and ran downstairs. She was sitting on a wall talking to her friends. She sees somebody come out of the woods. She also gives a description that we had to get out, which is consistent with everybody else, short and skinny, and also the same height that Tashita Saunders gave, which was 5'8" to 5'9". We shouldn't have to pull this information out. Your government should give you the objective facts and let you as the people decide. By tailoring it, they're not doing their job. Now let's talk about law enforcement. So let's talk about then Detective Collins. And let's contrast that with reasonable witnesses, objective witnesses. You remember earlier in the trial there was a couple of crime scene techs, the DNA people, the fingerprint people. That is objective evidence. Objective witnesses, when they testify, they answer the question straight. They're not trying to, find the answer. Contrast that with Officer Collins and also Officer Smith. Now, on Collins, we know, and we have the CAD notes. 5686, on his direct examination, the government got that out, that's his badge number. I'll zoom in here for you. He gives a description of 5'5" to 5'9". I don't buy it for a second that, I'm not sure. He could have just said, black male with this type sweatshirt running, unknown height. But he gave a description. Because the reason why you wouldn't do that, then if there's anybody tall, that's not the guy we're looking for. He gave the description that he had in that moment. He tried to be cagey. Compare him to how the texts were. We asked a question, the DNA expert. It could have gotten on there because of the T-shirt. Yes. Instead, him, from the very beginning of the cross-examination, he showed that he was motivated. When I asked him, and I go, you ran track and field, he paused because he knew that that was going to be bad for his testimony. I then asked him, you have to think about whether you ran track and field? And then he goes, well, you know, that was years ago. I'm not saying he's as fast as he was. I'm just saying that he's faster than this guy. 6'4", long legs, former runner, fit as anything as he took the stand. He wasn't given straight answers. Most importantly, we heard from Detective Smith, body cams. Where is Officer Collins' body cam that would have shown who he was chasing? At one point in his testimony, he talked about how recently he looked at the video and, you know, he determined that he was wrong. You know, people ask a question a lot on how wrongful convictions happen. That's how it happens. Because witnesses on the stand, Ms. Kawas and I have lived this case for years. We know the facts. And when he testified to that, you probably saw us jump up and our faces go beet red.
Yeah, sustained.
You saw the evolution of his testimony. He did what we're saying that the government is trying to do. They're trying to increase the size of the shooter to fill that gap. But what he doesn't realize is where he thinks that he's growing of the shooter, it's actually his own nose like Pinocchio. Because his lies, his attempt to lie, actually prove our point. Now the government, they showed a very small photo. This is their exhibit focused in. There's your shooter. All right, you can see right above him a black line in a window. That's Officer Collins. Now, if you toggle back and forth, you'll see that the shadow of the two is different. Now, I'm just pointing out a fact on what they didn't do. They talked about how there was a gradient at Renata Boston's home. What we don't know, and what we can't tell, is if that is perfectly flat, if there is a drop-off even of an inch from the driveway to the grass, and whether the grass is flat. I can assume the driveway is flat. But there may be a slight deviation. Now, in a case like this, an inch matters. But when you go back and forth between these two, it's important to notice that the shooter, and we'll talk about this in a moment, has something up underneath their hood. Latham testified that that would add easily a couple of inches. Now, Officer Collins got up there and said that he's 6'4". He looked about that, maybe 6'3". Sometimes, you know, guys will exaggerate, round it up, round it down. When you compare the two and put them side by side, and I'll draw a line in here for the window, right? And then I'll also do it for the window on the other side. So that's our point of reference. Now, if we estimate where the top of the head of the shooter is, because of what they have up underneath their head, that brings them roughly to the chin of Officer Collins. I don't know what the length of the average human head is from the top to the bottom, but I'm thinking it's at least 8 inches, 10 inches. They were hoping you wouldn't look at this closely, that he could just come in here and go, oh, I looked at this video years later, this very grainy, difficult to see video, and you want to know what? I was wrong. He was my height. That's preposterous, and the evidence shows that that is preposterous. We also heard from Officer Graham. We had to call him. They didn't. That's a police officer. Former police officer. We had to bring him in. He's one of the 2 police officers that chased on foot the shooter. Unquestionably chased the shooter. Why are we calling that witness and why are they not? They're not calling the witness because of the height description that he gives. It conflicts with their case. It's consistent with all of the civilians that we brought in, all of the civilians that testified, and Collins. The important thing is this, and any big guy knows this. There's no way a guy that's 6'2", 6'3", 230 is going to outrun a cadet that had just gone through the academy, that is going to outrun a former track runner. That's going to be, and remember what Graham said, he was jumping fences. He was fast. They were even in their cruiser for a moment trying to chase him. It was that fast. That ain't him. Again, quote his sister, hell no. What was Hakeem Robinson like then? The government wants you to, say, well, photos didn't need to be taken. Remember, we're the ones that brought in the photographs the day before. We're the ones that had to bring that in, and we also brought in Howell. But if we look, this is when the scan was done, the big piece of the government's evidence. You see the build on Hakeem Robinson. Now, there's little point of reference here. If you put him up to, next to Miss Quas, a normal-sized human being, he's huge. But even in this, you can tell he's got a belly. He is out of shape. He is not toned. And, Your Honor, I hope that I can quote what I did the other day when I said the shooter ain't got no ass. He does. In the video that we had to enter in, from the JSO property room where they show, and it's in evidence, you can look at it, I'm not going to play it now.
I'm sorry, I missed what you said.
Entered into evidence as Defense Exhibit 3.
Okay, I'm going to sustain the objection.
You can review Defense Exhibit 3, our exhibit. It shows Sergeant Howell walk out. And Sergeant Howell's 6 feet tall, like 300 pounds at the time. And Hakeem Robinson's taller than him. But you'll notice something as he's walking. Now, admittedly, he's wearing slides and he's walking. But big guys know this. They waddle a little bit. You ever seen a linebacker? The way that they walk, it's not the same as somebody who is fit and who is fast like the shooter. And you can see it. He has sort of a duck waddle in the way that he walks. It's a product of having big legs and being a big guy. Now, so in our exhibit we brought forward, now the government had an issue. Because Renata Boston says the person that walked out of the woods had shoulder-length dreads. Now, the government, they showed you an exhibit when my client was getting a pedicure, not a couple days later, it was almost a week later, 5 days later, and they showed from an angle up down where the hair, and one could think that looks like hair that's down to the chin because of the perspective of it. Our exhibit, our videos, shows what his hair was like 18 hours before this crime that he's accused of. He had short hair. He did not have shoulder-length dreads. There's no question. He did not have He did not have shoulder-length dreads. He had short twists. The government, though, has tried to fix this. They brought in a photograph. Of all of the photographs on Hakeem Robinson's phone, there were thousands, over nearly 5,500 photos. They find photos of the hood. They only show you a few of them. They tailor it. But again, this supports our argument. Now first, before I get into this, you look at the music videos, you notice, your times out in public before, he's not the only one with hair. If you look at the different type hairstyles in Charles McCormick's music video, in Hakeem Robinson's music video, there's a lot of people that have long hair. But this proves a point if we jump into the details. You notice how Hakeem Robinson, because he has sort of a uniform hairstyle, that the back of the hood looks as if it's empty. Now, obviously, it's lifted up off his head, but the back, it's got just fabric. You compare that over to the shooter, That is a different head. That is a full hood. That is hair. That is something up underneath there. Not that hair. Those are not, I'll go back and forth, those are not the same heads. Mr. Cooper got up on his closing argument and he said, Hakeem Robinson is 6 feet. And again, we're talking about tailoring the evidence, trying to shrink Hakeem Robinson, trying to grow the shooter, trying to jam a square peg into a round hole. That is not what the evidence was. The evidence for his height from first Blue, are we to trust him or are we to not? Because he said 6'2", 6'3". Johnny Shipes, no motivation whatsoever, not in handcuffs, not looking at prison. He said, I'm 6 feet. He's a lot bigger than me. He doesn't even fit into my clothes. Latham got up on the stand. And that's not what Latham testified to. He goes, the government did not ask me to do a height assessment. He agreed that the poor posture, not measuring for height, was 6 feet and a quarter inch. But he also said that there is an error of margin, very small. And we talked about the black tape line. I asked him, and I go, how thick is that tape? And he goes, could be 1 inch, could be 2, could be 1.5 inches. Again, I wasn't asked to do a height assessment, and you can clearly see that Hakeem Robinson is taller than that. And then anybody knows you get your height measured. When you go to the doctor's office, that little square is so small, so it forces you to put your feet together. You can get an accurate weight, you can get an accurate height. Again, they are trying to shrink Hakeem Robinson to fit. Stand up. You don't have to go based on that. You can look at him in this courtroom and make your own determination on the size of this man. Sorry, can we back up? And also the size of his feet. You can make that determination on your own. And when you do that, you can take a seat. Go back and look at the tiny little feet on the shooter. Latham said he would have the ability to be able to figure out the length of things. He spent nearly $100K on that guy to get up here and say, yeah, maybe. You don't throw in a few more dollars to get an accurate measurement of that foot? Let's go now to Sergeant Smith. February 5th, he's already committed on who it is. That's not an investigation. Literally days later, he sees an Instagram post. Now, what he says is, I screen recorded the Instagram post. We don't have the other Instagram stories to know what other things were out there. He just found one and he's like, this is enough. And he then commits to subpoena the meta records of my client. He had a print before that. We embrace that. That print was on that gun. It doesn't mean that he was ever inside of the car. And you know that he was in a music video holding all his buddies' guns. He was committed at that point in time. Print, post, he was done. His job was done. That's my case, but it wasn't enough. We got to build it a little bit more. Now let's compare this over to the other people that we know were involved. Varner, Butter, Blue, Abdul Sr., Abdul Jr., Torgon Williams, Natalie Bryan, Chris Brown. None of them posted anything. We use a phrase in these courtrooms every now and then, consciousness of guilt. That's consciousness of innocence. I'm going to post something would be wildly, days later, wildly stupid. The only person that's going to do that is somebody who is confident in their innocence. I am using this because this, unfortunately, and I don't condone it. I'm not a drill rap fan. But it sells records. And it gets followers. But him co-opting a lifestyle of people that grew up around him as an artist, doesn't mean that he's the one that committed it. I mean, look, country music stars talk about, murder. And look, I understand somebody actually died here. Rock stars will scream about murder. Other rappers will do it. We don't say that's a confession, but when it's a 21-year-old black kid from Jacksonville, it is. We're talking about the government and the way that they're trying to tailor the evidence. An opening statement, Mr. Cooper got up here and he showed you that post and he read it. I am never going to read that post. I don't have that right. First, they're assuming that's what it means. Right? Somebody could have a good day in court, post online, I killed it today. All right, so they want you to speculate that's what it means. But let's assume arguendo, that's what it means. So the government gets up here and they go a couple days later. A couple is 2, not 5. And then he says, getting his tired feet to try to say, oh, he ran and then went and got a pedicure after that. Again, 5 days later, nobody else is posting stuff. Everybody was trying to get away with his crime, and apparently he just goes out on public to his hundreds of thousands of followers, JSO watching, and confesses. The problem is that, look, there's 2 ways that you can look at the world. You can look at it through clean windows or dirty windows. You look at the world through clean windows, you're looking at it objectively. You start looking at it through dirty windows, everything you see is dirty. And that's what former Detective Smith, now Sergeant, did. He committed, and everything he looked at for Hakeem Robinson was through dirty windows. He was a hammer. That kid was a nail. He didn't look at anything else, despite the fact that there is clearly motive of other people. Chris Brown. We're not arguing that Chris Brown is the one that committed. I don't come into court and make speculative allegations. There was more than enough to look at it. So, Chris Brown. Renata Boston says that the guy that comes out of the woods has shoulder-length dreads. Natalie Gant gave us that little tidbit as well, too. Oh, yeah, shoulder-length dreads. Didn't have shoulder-length dreads, not even close. Butter pecan skin. It's clearly more brown than it is my client. I can't say that I confidently know what butter pecan skin is. I'm thinking of ice cream, but I'm thinking that it's more close to this guy. But there's one other glaring issue with that. Rothermill case. The murder crew is blue, butter, and brown. Crazy Chris. They literally have another murder case tied to Willie Addison. Smith gets up here and he goes, I don't even know his phone number. Talked about it in voir dire. You have to objectively investigate. You can't commit to a case, to a murder case, that is going to change the lives of so many people 2 weeks into the case. If he were looking at this case objectively, he would have looked into Brown. Oh, and don't forget, and I almost forgot this, Barner said Brown was involved. Now, someone would ask, well, why would Barner do that? I'm not asking you to understand the motives of a reliable hitman. I can't get inside of that guy's mind. I don't think any of us can. But is it crazy to think that in his mind he's thinking, first, I got to go with their narrative. But also, the more people I give them, the better my deal's going to be. Yeah, Chris Brown on 2 cases. That's not going to do much. But if you get more people, you can say, I gave you all of these people. There was plenty of people that had a motivation. Came out through Latham, it came out through Brown, it came out through other witnesses, that there was plenty of other people that would have been upset with what Charles McCormick did. None of them were looked at. None of them were evaluated. Instead, they spent the $100 grand to say that it wasn't two other people that we were never arguing that it was. They never acquired any records of Chris Brown. His Instagram, his cell phone records, nothing. Same thing with Dominique Barner as well, too. They don't get his Instagram stuff, and he said that he was on Instagram. He used it to stalk his prey, and also his iCloud stuff. It's willful ignorance. Now, I'm not saying that Smith sat down and go, you know what, I'm going to jam this kid. I'm going to make a choice not to look at it. But he lacked all objectivity within minutes on the case and didn't look at anything else, wouldn't even consider it. Let's change gears now and talk about House of Pain. So we're going to go into the topic now and talk about all the communications and the cell stuff. The government, like they're trying to link, they're trying to shrink Hakeem Robinson, grow the shooter. They're trying to bridge a gap as well, too, with the cell phone communications. They're invisible dots, imaginary lines. They're trying to get you to speculate. Now, first, they're trying to both say that, Hakeem Robinson was involved, that 478-305-9583 number, that was his, that he was using it. They're trying to connect all of that. But that's not what came out. They'll argue it, but it's not what came out, and that's why we're going to go over it here. First, with respect to the House of Pain email account, and they're trying to say, well, there's selfies of Hakeem Robinson in that account. Now, we know that Blue was trying to be the manager of his son, especially when his career was taking off. And any Apple iPhone user knows that you can combine, you can share photo albums. You know what makes sense as well? Something that they haven't disproved because they didn't get any of the further records, that he's uploading photos to his father's account so that his father can manage his Instagram page, to do something as a manager to justify getting payment. I'm not saying that's what happened. I'm saying that there is a hole in there that they're saying, well, they're selfies, it must be his phone, it must be him that's doing it. They could have gotten to the source of it. They could have gotten the Gmail records for that account. They could have gotten Blue's Instagram account, literally HOP, House of Pain CEO. But they didn't. Some could say willful ignorance. I'm saying that it's Sergeant Smith, Detective Smith deciding. It doesn't matter. I'm committed on what it is. Now, there's anomalies within the cell communications. Now, they've never actually tied Hakeem Robinson to that 478-305-9583. Smith got up here and he tried to say, well, the IP address, the first four. He's not an expert. We heard from two other cell phone experts. They were never presented with that information. He tried to say, well, the provider told me, that's hearsay. The provider told me that, it's the first four, not the last four, but I subpoenaed the wrong one. It was a 7, it was a 1, but yeah, it could be. Now, the government tried to say that based on what he said, it's a link. His words, could be. But even that is not even close to a connection. They had an FBI cast member agent up on the stand, didn't ask him any of those questions. You best believe that if they tied the IP address of that phone to my client, you would have had an expert from T-Mobile sitting in here going, here's your link. But instead we had Smith get up there and go, yeah, it could be. They're trying to blur the line, trying to connect him to the shooter and the phone to Mr. Robinson. Now, Blue says that he was worried about his son. Given his testimony, I don't think he cares about his son at all. But he says, you know what, I cared about my son. Whether it's him caring or not, there is not a single phone call to that number. You would think that if this is the phone that is being used in the commission of the crime, that somebody would be repeatedly calling it. Now they'll get up here and say, well, it could be a FaceTime call. We have no record of it in a data vet. Translation, they want you to speculate. They have never connected that phone over to the shooting. There are communications with one of the people much earlier, not during. There's a pin drop, could be in an area. They're wanting you to speculate. They need you to speculate because they have not made the connection. You remember, too, that they have the color-coded, they may show it to you here, that the red stands for that they even want to connect it before they've connected it because the 478 number is in red, and so is my client's known 1595 number. They have it both in red. The interesting thing is that throughout the entire time of the commission of the crime, you see no red. It's everybody else. Now, mistakes and anomalies with respect to glaring mistake. The cast agent, 7259, 7529, they admit it was a mistake, it wasn't entered incorrectly. Look, in other lines of work, could it be a scrivener's error? Oh, I thought you wanted it medium rare, not well done. In a murder trial, when you're trying to explain, to have a jury make a decision beyond a reasonable doubt, there's no mistakes. That was a mistake. And then we also have the anomalies with AT&T. And he said it, he goes, look, we can't, 95, I forget what the exact percentage was, but he's like, we don't use it because of the anomalies. But they still want you to trust some of the AT&T records. So, staying on the topic of the phones. Now, they brought up in the closing argument that Abdul Jr. had a phone that was registered to Darrell Watts, and that the 478 number was tied to Darrell Watts. What they're leaving out is that Ballou's main number was also registered to Darrell Watts. They also brought up this exhibit. It's a nice picture of Ballou. He looks like he's, indecisive, not the felon that he is. And they said, he's not going to send a message to himself. His email is literally right there, as if you're not going to see it. It's insulting. From his number, 2370, which is under Darrell Watts, sending it to 9583, and Abdul Robinson 71 at Gmail. Abdul Robinson Sr., born in the 70s, definitely not my client's email. They showed you this photo and made the argument he'd never send it to himself, where literally it shows that he sent it to himself. Let's talk about the DNA and the fingerprints. We, of course, embrace there is DNA on a shirt. I think it may be out here, maybe over there. With the white shirt. Doesn't prove that he ever wore it. We talked about it with the expert. If I were to take my client's handkerchief and wipe my brow, my DNA is going to be on it. And she also testified how that very easily could be the reason why there is a mixture, because they take a swab and they do the entire compartment, and that very much could explain, well, the t-shirt's sitting there, then we wipe everything, why there's a mixture and why it's so low. But we embrace that. His DNA is showing up on a shirt that's in the car and also on the dash. He was friends with these people. He rapped about the life that he lived. We are not denying that. He was around them. He knew them. Wasn't doing what they were doing, which is why he isn't covered in tattoos and bullet holes, because he's not living that life. Fingerprint, the music videos. So again, we embrace this, but none of that, and I don't need to go over it because I know you saw the testimony. But they both agreed objectively in their testimony, I cannot say he was ever inside of that vehicle. What we know is that his fingerprints are not in the vehicle, and there is not a 700 billion DNA reading of inside of the vehicle. There's a small mixture. The DNA expert got up there and said, yeah, it easily could have been transferred by the T-shirt. The reason why the government's probably arguing it is because they know jurors like DNA and fingerprints. No, it's like that silver bullet, but not here. This means all it proves is that he knows people that we already agree he knows. The other evidence shows that. So don't let them sway you with the idea of DNA and fingerprints. At the same time, too, we have Chifton Hogan. If their rationale of anybody whose DNA is found inside of the car, well, you know, they must be involved. Chifton Hogan and Blue said, oh, yeah, that's a family member to some extent. Anything that supports our argument that if you know people, your DNA could show up inside of their vehicle. Now, let's talk about the witnesses in this case. Latham, the expert. The government, and I said this before, they paid $80K, $70K, $80K, I don't know how much his expenses were flying back and forth and lodging, to come in here and say, yeah, maybe. Meanwhile, all of the witnesses consistently describe somebody that's short and skinny. Then they arrest a guy who's 6'2", 6'3", 230 pounds. That's not how the truth works. How desperation looks. Latham up on the stand, and I asked him, and I go, can you exclude me without scanning me? And his answer is no. And from that you can take, there's nothing unique about what he's saying. He can confidently say, well, it's not Leroy Whitaker, it's not Dominique Barner, not being argued here. But nothing more. Now the government, in their argument, they have brought up this photo. Now we have to talk about Charles McCormick's height and weight. Latham said, well, you know, they provided the information to me and I do the analysis. And what they gave me is that Charles McCormick was 5'10". There's a problem with that though, because I had to bring it out through the medical examiner, and he goes, that's just an estimate. Post-mortem, there are differences. Could be 5'9", could be 5'11". Also, this person is wearing shoes. So when that was brought up with Latham, he goes, I was given 5'10". I then. They call the medical examiner, and the medical examiner tells you that's not, I can't say that's an accurate height. But they want to do this comparison in between somebody who's 5'10" and then over to the shooter. We know that Charles McCormick was 143 pounds. We know that definitively. When you compare that over to the person next to him, now, Charles McCormick is obviously turned a little bit, and they're not in the exact same posture, and I'm not denying that. But I could also make the argument that he's wearing darker clothes, which makes things look smaller, and the shooter is wearing light clothes, which make things look bigger. What you don't see is a huge difference, 100-pound difference between the two people. See two skinny guys. Also, as for the height, yes, they are moving, they're dropped down. Let's do some math here. Hakeem Robinson, let's give him an inch, we'll say 6'2". Shoes, that's another inch. So he's at 6'3". Add then 3 inches on top of the head under that hood. That person's pushing 6'5", 6'6". If that were Hakeem Robinson next to Charles McCormick, 5'9", 5, whatever it is, he would be way taller. But he's not. Again, the government's trying to shrink it. They're glossing over the 3 inches that Latham said, yeah, that could easily be 3 inches on top of his head. I submit to you it could be more. If Hakeem Robinson, those little tiny feet, there's no escaping those little tiny feet. If you add an inch onto him, 6'2", 6'3", then whatever's underneath that head, that person is going to be a giant. You are not going to mistake that person for short and skinny, not a dozen times in a row. But they want to get up here and say, Charles McCormick, 5'10", despite what the witnesses said. Hakeem Robinson, 6 feet. tailoring their evidence because they know that the evidence itself, the facts, suck. Now, they may get up here and say, well, you know, we didn't need these witnesses. You cut a deal with violent felons and you don't need them? You cut a deal with Barner, who's a reliable hitman. You only get the reliable hitman term if you have killed. We know that in these cases there's nothing to establish him as a reliable. In Rothermill, they killed the wrong person, an innocent guy in a bike. On this one, he gets caught, but he's a reliable hitman. Sounds more like he's a serial killer. They may get up here and say, well, you know, we didn't need these witnesses, our case was strong enough. Then why cut those deals? He could be out in a matter of years. Blue has a likelihood of being out in a matter of months. That's desperation. Don't let them get up here and say, well, we didn't need it. They did. That's why they cut reprehensible deals with violent criminals. There's an internal conflict with their testimony, right? Now, they're felons, they're cooperating to get a deal. Let's put that aside for a second. So Barner gets up on the stand and says in the Rothermill case, implicating Blue on how he could have been charged with much more than accessory, provided items. Blue got up there and he denied. So which one's lying? It's not our job to prove it, it's theirs to prove, okay, well, this one's lying, but that one's telling the truth. As it stands before you right now, you have no idea. Schrodinger's cat. You have no idea who is telling the truth. But they want to put them up. They want you to trust these people, that they're pillars of truth. Because they came to them in handcuffs. Don't trust Johnny Shipes or Blue's daughter, who have no motive, and if anything, reasons not to come forward and testify. Mr. Shipes, Mr. Shapiro, because of his business. Blue's daughter, because she's basically saying that her father's lying in front of the judge that we'll be sentencing him. They have no motive. But no. Trust the people that came to us in handcuffs. Trust the people that we have on a physical leash to tell the truth. And again, we set aside the fact that they are murderers and felons. Don't let them get up here and tell you they're both telling the truth, that either of them are telling the truth when they didn't clear up that internal conflict in their own testimony. Now, Natalie Gant. They said in their closing argument, well, she had no motive. She absolutely did. You could see it on cross-examination. I could feel the breeze from her lashes fluttering at the counsel table as she was getting cross-examined about the motive that she has. Now, it's not about what this government thinks. As they sit there and smirk at you. It's not about what they think. It's about what that witness thinks when she's sitting on the stand. She knows Dominique Barner has implicated me in this case. I don't want to get charged. I'm going to do whatever the government says. Oh, and her husband sitting in prison being prosecuted by their office. It's about what's in her mind and the reason why she would have to tailor her evidence. Now, the government says, well, she didn't have all the details. She's older. She's not like the men she dates. She's smart. She knows if she commits too much, it could actually cause a problem. Oh, I don't remember what he was wearing. Because if she were to say the wrong thing, she's not usable. She hurts their case, potentially gets them mad, which is bad for her and her mind and her husband. The handguns. How would Barner know to say that the handgun was, look, Barner is not, I'm not saying he's book smart, but he's definitely street smart. He knows that there was, okay, and he was sitting on his case. He was getting prosecuted for months, looking at discovery before he ever made the decision to flip. He was arrested on the home invasion robbery. He had a whole bunch of records, and we're going to come back to that, on how he could have done what he did. But why would he claim that gun? Well, he knows that there's 3 guns in the vehicle. All right, one of them was used to commit a murder. The other one is a big machine gun. Yeah, that one's mine. Gave him musical chairs. He had to claim one. 3 people in the car, 3 guns. That one's mine. I'm not saying that the government, and if it's ever come off like this, I want to make this clear. I'm not saying that the government sat down with these witnesses and said, we need you to say this. Not saying that. Never would. But what I am saying is that they gave an opportunity to some really dangerous people. Dominique Barner is resourceful. He went on the court's computer system to stalk his prey, created fake Instagram accounts to figure things out in locations. He has a discovery on his case. We know that the first thing that was collected by Sergeant Smith were my client's meta records. The very first thing. Florida's a discovery state. This guy wants the government to be happy with him. They gave him too much of an opportunity. Now, the argument that we make over the recording, look, and we won't say it, the government has a right to talk to their witnesses. They're doing the work they need to do. They're talking to their witnesses. That's not our problem. Our problem is that the first and the second time they spoke to him, we have no idea what happened. Now, again, I'm not saying that these prosecutors told him what to say, but I do have any concern when the government is doing things behind closed doors, our government, without an ability to see it. And when they spoke to Dominique Barner the second time, Sergeant Smith told us they were leading questions. If you're getting the truth out of somebody, you don't have to lead them. You were driving the car. Hakeem Robinson was in the car. They're giving an opportunity for somebody to say the facts that they know the government wants to hear. And that's a problem that I have, that they allowed him that opportunity. Somebody that they knew was dangerous. Look, that serial killer has no problem taking a life. He has no problem lying to save himself. Sadly, we have no recording of the initial meeting. We don't know how he was able to get his facts straight, but I do know meta records are in the possession of law enforcement months before he cooperates. Florida is a discovery state, and he gets up there in another one of those times where we get new testimony. Oh yeah, he called Raekwon. You can clearly see that in the records. But what the government won't embrace is that my client's regularly talking to Raekwon, somebody that he's supposedly supposed to have a problem with. What that proves is he doesn't have a problem with these people, which is why he doesn't have bullet holes in him, that he's not living that life, that he's not tatted up. And we also know because after that, Raekwon Howard tried to kill people that we know were involved. Didn't go after the guy that he's talking to regularly and joking around with. So, it's very easy for somebody like Dominique Barner in a meeting. You know, Dominique's sitting there. Did Hakeem make any phone calls in the car? In the questions being asked by a prosecutor that's holding a stack of papers. Barner's smart enough to go, yeah. It's that simple, and it's that easy for that to evolve into, yeah, he was talking to, yeah. And that's ruling out the fact that he has the records. He was involved. He's going to get some of the facts correct. But he's also resourceful, again, on hunting his prey. This time, the prey was Hakeem Robinson. Now let's turn to Blue. Sat up here, fake tears, my son. Y'all saw it, there was no tears. He had that emotional pause. Yet he had no emotion when he was talking about the murder of his other son, Willie Addison. Abdul Robinson's daughter, no motive. If anything, reasons not to. I mean, of course, she doesn't want her brother wrongfully convicted. But she has reasons not to testify as well, too. Jonathan Shapiro, Johnny Shipes, no benefit, risk. Both of them gave a description of the height and the weight of Hakeem Robinson around that time, and it's inconsistent with what the government's saying. So, the government may get up here and talk about the fact that Varner and Blue are not sentenced yet, and that they don't know what they're going to get. That's by design. They got to make sure that they're dangling that carrot in front of them so that they do what they want them to do. It's also so that you as the jury don't hear what is potentially an offensive sentence that they get because of their recommendation. They want you to think, well, they could get life. There's no reason why they couldn't have been sentenced before coming in here. Now, one thing I want to go back on that I did miss. It's a really big point. And it's that both of them said, in government, I invite you to get up here and explain this one, that both of them said, Dominique Barner and Abdul Robinson Sr., have to say Ksoo to get the deal. Those are their words. I have to say Ksoo to get the deal. Let's talk about the jury instructions for a minute. I'm almost done here. So, when you go back into the jury room, one of the instructions you're going to get is weighing the evidence. And this is an opportunity for you to evaluate a witness's testimony. And these are things that the law in Florida says you got to be cautious of. We need to point this out to you because this could lead to a miscarriage of justice. Did the witness have some interest in how the case should be decided? Yeah, they're not spending life in prison. They're not getting prosecuted on multiple cases. Does the witness's testimony agree with the other testimony and other evidence in the case? I submit to you it doesn't. There's not massive conflicts, but there's definitely irreconcilable conflicts between their testimony. Has the witness been offered or received any money? We've already talked about Latham. Preferred treatment or other benefit in order to get the witness to testify. We are going to charge you with principle to murder. You're looking at life. You're a convicted felon 2 times prior. If you say what we want you to say, we'll recommend 72 months. Has any pressure or threat been used against a witness that affected the truth of the witness's testimony? You'll go out in 72 months, but you got to say Ksoo or otherwise you're looking at principle to murder. Did the witness at some other time make a statement that is inconsistent with the testimony he gave in court? Yes. Has the witness been convicted of a felony? Both of them, yes. Just one of these is enough. They're hitting almost all of them. They're not just felons. They're not just convicted felons. They're felons who traded a story for a deal to save themselves. They sat down with the state and told them what they wanted to hear, not because it was the truth, but because it was the price of their freedom. It's not justice. It's bargaining with guilt. The government wants you to trust them over all of the other objective, unbiased, unmotivated witnesses. That's scary. You know, the government, they may get up here and talk to you about reasonable doubt and say, you know, look, my job is I got to get you in a boat across this river. There could be holes in the boat, but I got to get you across the river. Now, I want to change and use that example, instead talk about waiver and vacillate, because that's what reasonable doubt is. You're standing there on the shore, you're looking at the boat. The boat got some holes, some water's coming in. You're told that there are anomalies with the boat, it was manufactured incorrectly and there's problems. Any reasonable person's going to be sitting there going, I don't know. That's waver and vacillate. But add on top of that, the two people that are captaining the boat are violent felons, and they're telling you, hey, this boat's fine. No reasonable person's getting into that boat, and that's what they're asking you to do. Let's talk about their burden. Their burden of proof. I'm not going to go through this or spend much time on it, but just for the illustration of what we're talking about beyond a reasonable doubt. Everything else below that, strong belief, guilt likely, probably guilty, possibly guilty, none of that is enough for them to carry their burden. They have got to be able to rule out every other possibility. But the case that they presented to you, there's a whole bunch of other reasonable ones.
All right. The jury will listen to the instructions as I provide them to you, but you may proceed with argument.
They can't carry that burden. They have too many holes in their case, which is why they're not embracing the actual facts of the case and instead trying to mislead you. Now, whomever for the government gets up here and does the rebuttal, they may try to sway you with emotion, show you photos of Charles McCormick, talk about the tragedy. So let me save them that time and do it here for you. What happened to Charles McCormick, what happened to his family was tragic. No parent should have to bury a child. It's horrible. Convicting the wrong person doesn't fix that. It makes sure that the person that actually committed it, or other persons, go free. It doesn't protect us here in Duval County. Hakeem Robinson deserves better. The people of Duval County deserve better than Detective Smith getting up there going, yeah, that post was enough. The McCormick family deserves better than that. The emotion of this, the understandable emotion of this case, though, there's no place here. That's an attempt potentially to sway you into a verdict because the facts aren't enough to do it. So I'll save them that time of making that argument. In a short amount of time, you're going to be back in the jury room, you're going to be deliberating. You're going to be asked to make a determination whether Hakeem Robinson is guilty or not. Again, to quote his daughter, hell no. Thank you.